Supplementary cause list, item number 1 for pronouncement of judgment.
Who's on the other side? I'll read only the operative portion. Finally, in conclusion, this court finds that the impugn order of discharge or acquittal cannot be sustained and the same is hereby set aside and quashed. Trial court is directed to take up the case for retrial de novo. Deployable. Thank you. Yes.
I'd like to make a motion. I'd like to move an unlisted motion today, Your Lordship. The reason being that just this morning we learned that Monday happens to be a holiday for the Meghalaya High Court, and we could not file this said writ petition yesterday also, being another holiday. And the urgency in this matter is that recovery proceedings are stipulated to be undertaken on Tuesday. Therefore, my Lord, today is the only working day wherein we can move it, and this is regarding default of payment of loan interest. Therefore, my Lords, I pray that this may kindly be taken up anytime during the course of the day, my Lord.
Okay. You are there?
Yes,
Obliged.
I'm along with them.
Please.
I do, Lordship.
Obliged.
Yes, anything?
May it please, Your Lordship. Your Lordship, I beg to mention item number 8, Your Lordship. Your Lordship, the conducting counsel, Mr. S.N., is not available today, Your Lordship.
This will go to next year.
This is appeal against old land acquisition 54.
Evidence has to be reappreciated. Evidence has been led in this case. Degree has been,
Everything.
the award has been passed.
Everything ready.
You are for?
I'm for the state respondent, Your Lordship.
You also here, Miss?
Yes, I'm here, National Highway Authority of India.
On prayer made by the state respondent seeking accommodation, the same not being objected to by the Senior Counsel for the petitioner, for the appellant, matter is adjourned. This is here after 2 weeks.
Obliged, Lordship.
I beg to make a mention of item 9, my lord. But here I require a week's time. Apologies, my lord. Item 5. My lord, I require a week's time more, my lord.
This is just for filing of your written
Yes,
argument.
my lord. I have completed 80% is done, my lord. So a week's time I'll be able to file, my lord.
You are, what about you? Have you filed your? We will fix it after 2 weeks. On Mr. K.P. Bhattacharjee, Leonard J, appearing for the state respondent, has once again sought for accommodation in this matter on the ground that the written argument sought to be filed today could not be done so. Premier, this seem not be objected to by the petitioner. Matter is adjourned. This is after 2 weeks.
Well, I'd like to make the mention of item number 6. Is the matter will have to come 2 weeks, my lord.
This matter has been heard
No, my lord. Yet to be heard.
for 2 weeks. On private by the petitioner, not objected to by a respondent. This is not after 2 weeks.
Much lord.
Please, Your Lordship. Lordship, I beg to make a mention of item number 11. As the learned TSGI Dr. N. Mosika is currently out of station, Your Lordship, I pray if this matter may be listed after 2 weeks.
This contempt matter,
Yes,
is
Lordship.
it connected to those writ petition to your file?
Yes, Lordship.
Connected?
It is connected with the writ petition. No, those two writ petitions. It is in writ petition number 418. It is only connected because this is relating to the this issuance of adverse
Yes, yes.
remarks in the
that
certificate, character certificate. So that was a challenge in WPC 418 with the direction only to rectify the certificate.
Then why this contempt?
Contempt is, Lordship, there is clear contempt and so punishment, Lordship.
With regard to the issuance of the certificate?
Lordship.
Fine, we'll see. No, what I thought is, the matter could come together.
It can
if
be
it is,
separately.
if it is
It can
connected
be.
already.
Here they have admitted also in that they tendered an apology in para 2 and 22.
Then what else? What remains?
Lordship,
If they have tendered their apology, then matter ends.
whether that is acceptable to the court or not,
We'll look at it.
that has to be seen, Lordship. Under the facts and circumstances, they do anything and then come to the court and say, we tendered apology.
It's not only a question, a simple tendering of an apology. It's a question of repairing the damage done.
Yes. If Lordship deemed fit and proper that it this after apology is accepted and the matter can
Yes.
be closed
See,
off. This is up to the Lordship discretion.
If
only, Lordship.
if in that respect it causes you no further harm, then what's the point of let it?
Lordship may hear this contempt matter and decide.
Fine. On prayer made by the respondent and objected to by petitioner. This is matter of 2 weeks.
Lordship, here the office note indicates that on 3/11/2023, the power in respect of respondent number 2 has also been filed.
Okay. Okay, we'll look at it.
Obliged, Your Lordship.
Lordship, I beg to mention item number 9 from the main list, Lordship. Some difficulty, Lordship. Here, senior counsel is out of station, Lordship. We have it, Lordship. Please,
This matter has been heard.
No, Lordship.
No, my lord, it was not heard.
Not heard, Lordship.
We are still on that issue of a revision and
Yes, either it is revision or appeal.
Lordship.
That is the.
that has not been clarified.
That part, Lordship, I suppose that part is done, Lordship. Now,
that is
that
part.
part is-
Oh, that you mean to say that revision would lie,
Lordship. Now it is
and,
fixed for hearing,
and the
Lordship.
court can reappreciate evidence.
Not to the limited extent, my lord. It was argued at that point that yes, entire evidence cannot be gone into in the revision, my lord. Entire evidence and everything, my lord.
See, what is revision? Revision is basically only
Legality,
to
my lord.
look into the legality, illegality, and mainly on the issue of.
What was just now discussed, whether appeal will lie or revision, and the scope of.
Your Lordship would like to make a mention of item number 12. The conducting counsel, Mrs. N.G. Shilash, is on leave.
She's for the bank.
She's on leave, Your Lordship.
She's paying for the bank.
Yes, Your Lordship.
Then what has the bank got to do here? I think
For the
mostly
petitioner.
it's for the
Bank has nothing, not much role to play. It's mainly that whether they have filed this petition, and I have stated that it needs to go for appeal, and this
so-
court has at present this court has no power to try WPC
So we'll have to look only at the scope of section 75.
sections. Yes,
Is it 75 or 7?
7A,
7.
7I.
7I.
We are just on basis of the section 7I.
So
So
we'll hear the matter then.
if they are ready, I am ready. Because bank has not much role to play. Whatever the court's order, bank has to
because-
comply. Because for us, we need to recover. So if unless and until as per like court's order on last date, like they are supposed to deposit some amount, but since court has already what we have seized the means we have freezed the account. When we have freezed the account, court was inclined towards them, and they have court has directed them, okay, defreeze.
On the assurance that the account which is used would be utilized for payment of the
Payment,
current dues or whatever, since that is the only account
Yes, so now they have they are not paying, they are utilizing the fund, but they are not paying the APF dues. So myself also, we have not come forward, because my only contention is that if this court has no power to try WPC, it has only the appellate authority has the power to try, then everything will suffice. So myself also, if I bring any petition, then they will be filing reply to that petition. It will prolong the matter.
No,
So
so
just
now
to
we
avoid
are, so we are now only on the issue of maintainability.
on the maintainability. So now if they are ready to proceed with the matter, I am almost prepared. Whether they are,
The conducting counsel is on next, Your Lordship.
We'll take it up.
For week's time, Your
Hey, let
For week's time,
Miss,
Your
what is there for you? We'll do one thing. Let the matter be called up. If at call we are required, your argument is required, then we can hear you on the next date. In the meantime, at least we'll hear the petitioner and the main respondent. Let us see.
Your Lordship, I beg to mention item number 4. Lordship, I'm praying for weeks times of competition, Your Lordship.
Weeks too. Oh, this matter is only part heard. Now again you have to start from.
But state has got limited role in lordship. Basically, it's for the Darbar and KHDC.
Oh, okay.
Some issue.
With regard to that, jurisdiction of the Darbars, no.
Lordship is correct. Slight issue of law.
Which would KHDC is a party here?
Yes. And the local Darbar also is a party. So whether the rules of KHDC are applicable to Darbar. It's an important issue of law involved. Yes.
Mr. Kanta is there.
No, he is there. DC.
Can't hear you. Sorry, Mr. Your microphone is off. Very sorry, I'm not good at lip reading. Anyway, they have asked for time, so we'll give them. On pre-made by petitioner, this is matter up to 2 weeks.
Similar prayer for item 7, Your Lordship. Item 7.
Well, practically there'll be nothing else.
I have no objections, Your Lordship.
You're for petitioner.
Petitioner, Your Lordship.
You're for?
I'm from the respondent, Your Lordship.
And pre-made by the
Respondent 1 and 2, Your Lordship.
respondent 1 and 2. That is adjourned. This is same after 2 weeks.
I oblige, Your Lordship.
From daily cost list, item number 1.
Please, Your Lordship. Lordship, as Lordship would have seen on the last occasion, my friend appeared for the private respondent. That is number 7. Number 8 and 9. That's enough. Because number 8 is the school, number 9 is the managing committee.
So 8 and 9 you're appearing. What is this matter about, Mr.?
It's a review, my lord. It's a review against my lord's judgment. Possibly they may want to file a reply against this review.
I want to file. Reply against what? Against the review. But initially we are here on the issue of condonation of delay. Yes. Isn't it? That has not been condoned. Was it?
List. Yes, my lord. There is a delay of 52 days, my lord.
All the respondents are in attendance now.
Yes, my lord. Yes, my lord.
Heard Mr. S. General, counsel for the applicant, who has submitted that this application, that the petition, the review petition has been filed before this court. However, a delay of 52 days has occurred in the same, while filing the same, which was not intentional as far as the petitioner's review petition is concerned. On good grounds shown, the delay is condoned. Petition, this case number is hereby disposed of. Registry is directed to direct the main review petition to allot a number accordingly, allot case number accordingly. Are you accepting notice as far as the main petition is concerned?
Yes, private respondent.
All. How to main case, since all the respondents have entered appearance, have accepted notice, no further notice is required to be issued. Accordingly, this is matter for hearing after 3 weeks. But you want to file? You want to file? Fine. So we'll give you 2 weeks time then. The respondent, as prayed for, are allowed to file the response, if so advised, within the next date fix. This is matter to 2 weeks.
Item number 2.
Yes. Who's appearing?
For respondent.
I am also for the respondent, Your Lordship.
All the respondents have filed their counter.
Your Lordship, as per the last order, the petitioner seek time to file a rejoinder to our affidavit.
Yes, rejoinder.
We have
But
all filed our affidavit.
you have not filed.
We have all filed.
That's what I'm asking. Have all the respondents filed their counter?
Right, Your Lordship.
So far, I am concerned, Your Lordship. I had filed a petition challenging the maintainability of the writ petition.
That will be heard then. Issue of maintainability
Yes.
will be taken up.
Yes, Your Lordship.
None appears for the petitioner. Office note would reveal that the rejoinder affidavit on behalf of the petitioner has not yet been filed. Accordingly, the petitioner is directed to file the same within the next date fix.
Your Lordship, can I suggest a date, 30th of November? There is another connected analogous matter also.
It may not have any connection bearing, because this is only for filing of the rejoinder. But anyway,
Yes, Your Lordship.
since you say,
If it can come on the same date, because both are the same writ petitioner, Your Lordship.
can you take it?
30th.
11, if I'm not wrong, Your Lordship, the other writ petition, analogous matter.
6 on?
11th of December.
11th, Mr.
Oh,
Writ
I thought
petition
30th.
263.
Okay.
It may come on 11th, so
Yes, Your Lordship.
this is matter on 11th.
Much obliged.
11 December.
Obliged.
Item number 12.
May it please, Your Lordships.
Please.
Lordship, in very short, my lord, the claim is, my lord, that I am a school and they are the EPF and I am supposed to contribute to the EPF, my lord, as per the Act. Here, my lord, the notice which has been issued to us is issued for a period of dues, my lord, pertaining from the month of February 1992 to April 2008. And the amount, my lord, which they are claiming comes to about 4.7 lakhs or so. Now, my lord, without going into any dispute or anything, I have, my lord, 3 submissions to make for the humble consideration of this honorable court, my lord. Firstly, my lord, that the period between the period up to March 2000, here, my lord, they have issued the notice starting from February 92. But my humble submission is, my lord, that the period up to February 2000 has been waived or deemed to have been waived in view of the previous litigation between the parties before this honorable court. And I'll try to satisfy your lordship on that, my lord. And as far as the period from March 2000 till April 2008 is concerned, we have no dispute with the amount which they are claiming for that period, my lord. But it is my humble submission, my lord, that as per the Act itself and the scheme under the Act, I am entitled to pay only 25% of that amount, because that is a delay of more than 1 year. So the provision is for 25%, my lord. To substantiate, if I may, lord, if lordship kindly comes to page 31 of the writ petition. Lordship has page 31.
Yes.
Lordship, page 31, my lord, is the order passed by this honorable court on 13th of December 2011. And my lord, the writ petition was titled as WPC 58SH of 2009. It's not mentioned here, my lord, but that is the case number, lordship.
Why it's not mentioned?
That, my lord,
First time I've noticed this kind.
It was the erstwhile bench, my lord. This was in the erstwhile Guwahati High Court. In fact, even the name of the court is not very well mentioned. But the WP number would be, my lord, WPC 58SH of 2009. No dispute with that. That WP number.
WPC SH
58
of
2009, my lord.
2009.
Decided on 27th January 2012.
Okay.
At page 31, my lord. If I may read, my lord, this is pertinent, my lord. This writ petition is directed against the notice dated 6th March 2009, Annexure 12, issued by the Enforcement Officer, EPFO, Sub Regional Office Shillong, Respondent 4, for payment of dues under Section 14B of the EPF Act, together with interest and damages, cost and expense of the recovery process. So here also, my lord, a similar notice has been issued under 14B. The case of the petitioner is that his school was arbitrarily brought within the purview of the Act in the year 2000, but with effect from 1983. He then informed the respondents that the school had only 20 employees from 1996, and therefore contended that the school should have accordingly been asked to deposit the EPF dues only with effect from 1996 and not with effect from 1983, when the school did not have 20 employees or more. Now here, my lord, his representation to that effect, however, was not accepted by the respondent authorities, and the school was thus asked to deposit the EPF dues with effect from 1983. The school accordingly paid all the dues as directed. However, to the consternation of the petitioner's school, the respondents in their final order dated 25th May 2004 levied interest and penal damages upon them with effect from February 1996 to March 1999 for the alleged delay in depositing the dues. This prompted the petitioner to approach the respondent authorities on 1/11/2004 to waive the interest and damages on the ground that there was no delay inasmuch as the school came under the purview of the Act only from 2000, while the school started to have 20 or more employees only in 1996. The representation was rejected by the respondent authorities on the ground that there was no provision under the Act for waiving damages, and so on, my lord. Now, lordship will kindly come, my lord, to page 34, paragraph 5, lordship.
Yes.
If I may read, my lord. Resultantly, this writ petition is allowed. The impugned notice dated 6/3/2009 is hereby quashed. The respondent authorities are therefore directed to allow the petitioner to pay 25% of the total damage of the period between March 1996 and February 1999 in accordance with clause 32F of the Employees Provident Fund Scheme 1952. The installments already paid by the petitioner may be adjusted against the balance payable in terms of this order, no rest to cost. So here, lordship, the period from March 1996 to the period of February 1999, my lord,
Yes.
has been dealt with in this order itself, lordship. And it is not anyone's case that we have not complied with this order. Now, my lord, if lordship is pleased to come to page, lordship, 40.
Yes.
Page 40, lordship. The order begins at page 38. 38 is the cover letter, my lord. The order begins at 39, and the operative part is at page 40.
Yes.
Lordship has paid 40, my lord. The second paragraph from the top. Now therefore.
Yes.
Lordship. Now therefore, I so and so, Regional Provident Fund Commissioner to Shillong, in exercise of the powers conferred on me by Section 14B. So this is the same section, my lord, as in the earlier round of litigation. And on application of my mind to the facts and circumstances of the case, and on perusal of relevant records, consider it fit to be a case for levy of damages as per the rates prescribed under para 32A of the EPF scheme 1952, 5.1 of the EPF scheme 1995, and 8A of the EDLI scheme 1976, notified by notification dated so and so issued by the Government of India, and accordingly ordered that the damages for the delayed payments for the period February 1992 to April 2008, totaling to rupees 4,63,871, be recovered as per the account wise schedule indicated below from the employer in relation to MS St. John School, Whitehall, Lordship. Now, my lord, as I've pointed out, my lord, the period up to February 1999 had already been taken care of, and there was even a finding that we have in fact already paid earlier, and the balance would all to be adjusted, and that in compliance to that order, my lord, passed by this honorable court, we have paid, and they have also not disputed. They have not filed an appeal or a contempt. Now, my lord, to again ask to rewind the clock back to 1992, in my humble submission, my lord, would not stand. And they ought to, my lord, start my dues, if any, from March 2000, because till February it had been waived. It had been already paid in view of the earlier judgment passed by this honorable court, my lord. So, for the period from the period of February 1992 till the period of February 2000, they could not have asked me for any damages, lordship, because I had already paid in view of the last round of litigation. Now, my second submission, my lord, for which lordship may kindly again come back to the previous judgment, my lord, at page 33.
Yes.
Page 33, lordship. I may be allowed to begin from page 32, paragraph 3, my lord.
Yes.
Page 32, paragraph number 3, my lord, right at the bottom. In my judgment and order dated 1/7/2008, passed in connection with WPC so and so, followed by another judgment passed by me on 12/8/2008 in WPC so and so. In cases somewhat similar to the facts of the instant case, I reduced the payment of the damages to the extent of 25%. These orders have not been challenged in an appeal. Needless to say, those judgments were rendered in terms of the decision of the Apex Court in Halwasai Vidya Vihar versus Regional Provident Fund Commission, AIR 2006 SC 1767, which is binding upon this court. However, the law on this point has now been changed by amendment of the Employees Provident Fund Scheme 1952 in 2008, which came into force with effect from 26/9/2008. The amended provision is found at 32A in the following terms. If I may read, my lord, 32A, recovery of damages for default in payment of any contribution. 1. Where an employer makes default in the payment of any contribution to the fund, or in the transfer of accumulations required to be transferred by him under subsection 2 of section 15 or subsection 15 of section 17 of the Act, or in the payment of any charges payable under any provisions of the Act or the scheme, or under any conditions specified under section 17 of the Act, the Central Provident Fund Commissioner or such other officer as may be authorized by the central government by notification in the official gazette in this behalf may recover from the employer by way of penalty damages at the rates given in the table below. Lordship will see, my lord, period of default A less than 2 months, and the rate of damages, my lord, 5%. Similarly at B, my lord, 2 months and above but less than 4 months, it is at 10%, lordship. And C is for 4 months and above but less than 6 months, which is at 15%. And lastly D, lordship, 6 months and above, 25%. Even the even a cursory look at the foregoing table will make it plain that for the default of some typographical error exceeding 6 months and above, the damages recoverable is fixed at 25% of the arrears per annum. The amendment is in accordance with the judgment of the Honorable Apex Court and so and so. There can be no two opinions in this behalf. The respondent authorities cannot recover damages exceeding 25% per centum of the arrears per annum, even if the period of default is 6 months and above. In the view that I have taken, the impute notice issued by the respondent number 4 is liable to be interfered. So here, my lord, my second submission comes.
What was the impute notice there?
Lordship, the impute notice, Lordship will kindly come back to my lord.
No, the impute notice referred to in this judgment.
I beg your pardon, Lordship.
So the impute notice referred to in this judgment?
Lordship, the impute notice was for a period from 96 to 99.
Okay.
Which Lordship will again find at page 5, paragraph 5. So what this Honorable Court had done, my lord, is it set aside the notice as it was, but directed me to pay for that period
as penalty
at 25% as the penalty in view of the amendment and the judgment of the Honorable Supreme Court. And here also, my lord, the claim which they are making in this present situation is more than 6 months. And as per the law itself, I am supposed to be liable to pay only 25% of that amount. So my humble submission is, my lord, that the impute notice may be in similar lines, my lord. Firstly, the period up to February 2000, which was paid in accordance with this judgment, they cannot, my lord, ask me to again pay it. That will be a double jeopardy on me. And secondly, my lord, the remaining period, which they are saying that we are liable, without disputing the total amount, we are willing to pay 25% of that amount, my lord, in view of the section 32A and the judgment that has been laid down. So those are my humble submissions.
So you admit that there has been a default?
Yes, yes.
But now the only issue is computation of the period.
Computation of the period, and after the computation of the period, the amount will be recalculated and I'll pay 25% of it.
That will, it will follow suit.
Because I cannot dispute the total amount, then I have to go for an appeal and other provisions are there. But here I am not disputing the amount.
So see, in the light of this judgment, you see, if you look at this judgment, between
the same parties,
the period till 1999 has been covered.
February.
Lordship, if half of the fact is placed, then there is always a Lordship. The Lordship will not come in a proper conclusion, Lordship. If they have placed, that is why Lordship in during first argument only I said they have not come in a proper clean hand, Lordship. Now, Lordship, in section 7I, Lordship, if the act is with you. 7I, Lordship. What 7I says, I'll come one by one, covering all the points. Lordship, if any mistakes has been conducted by any seniors or anything, sometimes the Supreme Court also says that since this is not the appellate court, it's a brother court, so it is not so binding on this court also, because the judgment which they have placed, because sometimes the Supreme Court also says that we are not inclined to.
You mean to say that the judgment was passed on a wrong premise?
Wrong provision.
Should have appealed, my lord.
Lordship, see, since Lordship, I am Lordship is aware that in the judgment also my name is not reflected.
No,
so I came much later.
We are not talking about you.
No, Lordship.
We are talking about you. We are talking about the clients that you are representing.
Yes, Lordship. So, Lordship, it is the judgment was passed, but now we are into rectifying the judgment to go for appeal, but it is too late. But still, Lordship, we are the provisions should be clear before arriving at any conclusion, Lordship.
Lordship, can
now,
you for 1 minute?
Lordship, now, if 7I, if we can, Lordship, can come to 7I, what are the grounds where we can come to the appeal grounds, Lordship?
Appeals to
Appeals to tribunal. Lordship, any person aggrieved by a notification issued by the central government or an order passed by the central government or any authority under the provision to subsection 3 or subsection 4 of section 1 or section 3 or subsection 1 of section 7A or section 7B, accept and other rejecting an application for review referred to in subsection 5 thereof or section 7C or section 14B, the order which is passed under section 14B, may prefer an appeal to a tribunal against such notification or order. If anything which they are not it is not said that disputing amount or anything. If you are not satisfied with the order, you have only one option: go to the tribunal, which I have replied to them when they have sent me legal notice. I have clearly stated that you have an option to go for appeal if you are not satisfied with my order, but still they did not opt for that. Rather, they have come before this honorable court to make the matter more delay. I would rather say that every appeal under subsection 1 shall be filed in such a form and manner within such time and be accompanied by such fees. Now, to file an appeal, they have to pay fees to the tribunal. So I would rather say that to avoid that fees, they have come before this honorable court. Because to file an appeal, they need to deposit some amount. This shows their malified intention when I have already apprised them that you have an option to go for appeal, because the section says so. It is not saying that you are if you are disputing half amount or full amount or whatever. It is saying that if you are not satisfied with order under section 14B, you can directly file an appeal. Where is it? The provision says that they can come to High Court. There is no provision.
Yes.
Now, after this thing, Lordship.
I think that, you see, that is a point of law. Mr. Deb, you have not addressed that issue.
No, they have not addressed. That is why I am saying, Lordship, they have not come before. They have not come before honorable court before this honorable court clean hand. Lordship, now my affidavit which I have filed. Lordship, you are Lordship, Annexure F, page number 18. The Lordship.
Definitely. Annexure F, page
Annexure
18.
F, page number 18, Lordship.
Yes.
Lordship, may I? Now, Lordship, if we come to the reading entire thing, it's useless, Lordship. Now I come to directly to the period of delay, Lordship. That column is made out.
Yeah.
Lordship, if we go directly to the act, sometimes the confusion comes because we are not so much with the calculation part. We are not technically or mathematically we are so strong to calculate. Here they have already calculated the period. Less than 2 months, rate up to 25/9/2008 and rate from 26/9/2008. This is the period of rate given. So less than 2 months, rate up to 25/9/2008 is 17%. Rate from 26/9/2008 is 5%. So 6 months and above, 37%, and rate from 26/9/2008 is 25%. So how we will count, Lordship? It is prior, Lordship, 2008. So 37% it is counted. It is already given the calculation. If they have not gone through this notice, then Lordship, first and foremost, first notice has to be gone through. Then you come to the order sheet. What we have explained to them. So according to the rates, how we have derived into the calculation also I have to show, because 14B, what 14B says now, the act, if we come to the act, what 14B says. What is 14B? Here.
14B, yes. Power to recover damages.
Yes, power to recover damages.
Yes.
When an employer Lordship,
yes, please.
Yes, when an employer makes default in payment of any contribution to the fund, may it be pension fund, may it be a thing, or the insurance fund, or in the transfer of accumulation required to be transferred by him under subsection 2 of section 15 or subsection 5 of section 17, or in the payment of any charges payable under any provision of this act or of any scheme or insurance scheme, or under any of the condition specified under section 17, the Central Provident Fund Commissioner or such other officer as may be authorized by the central government by notification in the official gazette in this behalf may recover from the employer by way of penalty such damages not exceeding the amount of arrears as may be specified in the scheme. Now, Lordship, we cannot go beyond the amount, like such amount not exceeding the amount of arrear. It cannot be exceeding the amount of arrear. we are below the amount of arrear what we have calculated, 37%, because it is the rate up to 25/9/2008. So it is 35%, 37%, 37%. We are not going beyond. If we go beyond, then 25% will be counted. First, we have to understand how it applies. The provision that before levying and recovering such damages, the employer shall be given a reasonable opportunity of being heard. We have given ample time. Provided further that the central board may reduce or waive the damages levied under this section in relation to an establishment which is Sikh industrial company and in respect of which a scheme of rehabilitation has been sanctioned by the Board for Industry and Financial Reconstruction established under section 4 of the Sikh industrial companies. Special provision 1985 subject to such terms and conditions as may be specified in the scheme. So, Lordship, thereafter, Lordship, now kindly come to page 20. This is how we recover damages. Kindly come to page 20, Lordship. (1992) when they have paid is 2002.
Yes.
Due date is 15/3/1992. When they have paid, it is 2002.
Where is that? Just hold on.
Page number 20.
Yes. Okay. So due date, presentation date. Okay.
Yes. Then subsequently same they have paid in 2002. Now thereafter, where they have paid, we have already marked. Page number 21, we have marked paid. Page number 21, page number 22,
Yes.
page number 23.
Yes.
All paid we have marked. So we have deducted also where they have paid, where they have showed us proper challans, where they have this is like if we have by mistake we have calculated, if they have if they are showing proper challans, we have marked it paid and we have deducted from the from their amount, that amount.
Okay.
All the days, Lordship, till means up to 2008. From 2008 they have paid in 15/5/2010. So what is the amount when they are making each time delay? Then it is automatically getting calculated.
So what you are trying to establish here is for the period after 1999.
From 1999.
Yeah.
1992 also is there. 1992 is also there. They have paid, but they have paid in 2002.
So as far as that, that period of 1992 till 1999, whatever,
Yes.
would be covered by that the earlier judgment.
Lordship, it will be covered, but Lordship, the thing is that Lordship, you have it is covered, but
Covered in the
Lordship,
sense that they are required to pay, but subsequently they have not paid even till 2002.
yes.
So then the other comes.
Then the calculation comes. Obviously, there is a period of delay. They are supposed to pay.
Yes, yes.
There is a period of delay. If there is a period of delay, if they are not satisfied, then they are supposed to go for appeal.
Exactly.
Not before this court, because this court has appellate power. After tribunal, they are not satisfied, then they come. But as a writ power, there is no provision.
Yes, please.
So, Lordship, since all the calculations are given, 37, what I have stated is that till 2008, up to 2008, it is 37%, more than 6 months. So, according to the 37%, they are in page number 18, Lordship. If Lordship is in page number 18 of my affidavit.
Yes.
The calculation is given, Lordship. The second column, how we have derived.
Yes.
Now, after the first column, Lordship, now the scrutiny of the records maintained by this office for the remittance made by you during the period from 96 to 2014 shows that there are certain payments which were made after the respective due dates, and the total amount by way of penalty and the amount of interest on such belated payments are under annexure A. EPF contribution in account 1 is this amount, interest is this, total is this. So this is the calculation we have given. We have given entire calculation.
So EPF contribution in account 1. So
One is
2,98,000 is the area or the damages.
Yes, amount of damages.
Okay. So this is the default amount.
Yes.
And then interest at 37%.
Yes.
Total is this. And the total of all this comes to 6,87,000.
87. But then it was like thereafter we have deleted some amount, then we have given them 4 lakhs. Yes. 4.7 lakhs.
How did you?
We have then the calculation which we have showed that we have paid. They have paid. So we have deleted those amounts also. The calculations we have deleted, and then we have come to 4.7. The damages we have eliminated the damages for those periods.
Where is that? That should have been by way of a corrigendum or by way of subsequent communication?
Lordship, yes, Lordship, page annexure I,
Each.
page number 34.
Okay, so this is the one.
This is. $4,63,000. Yes.
Okay. So this
7Q is interest.
So this is only till April 2008.
Yes.
1992 to 2008 April. So that slab of 37% is still applicable here.
Yes. Because 2008, 37% is still continuing.
Yes.
So, in the light of this lordship, whatever I have placed, lordship, in the light of this lordship, I pray that this writ petition is not supposed to be entertained, lordship, because the provisions is very much clear, lordship. They have not they have not complied with the provisions. They have intentionally not paid the amounts, which is, they are very much aware that 15th is the day which is the every month 15th is the last date for payment. They are intentionally not paying. So if accumulated interest they start gaining, then how the beneficiaries will get their amount? That is why Meghalaya college teacher is suffering. That is why the other schools are suffering. We are in college teachers also, we are fighting that the college teachers should get, because the authorities, they are not giving them the opportunity, lordship. If pension schemes is there here, what happens? 8.35 is employees provident fund, and 3% something is goes to employees schemes. So, pension schemes, some amount is distributed to pension schemes, so that the beneficiaries who are the provident fund beneficiary, they can get at least retirement benefits. Because of this entire process, those who are getting retired, how they will get the amount, lordship? How they will claim? In Comora also we are saying, now Comora is coming up with the you are very much aware, lordship, because the same matter is in before this court, that now they are bankrupt. They are like they cannot pay the dues. They are the employees, they are suffering. After all, if the management is not complying, after all, who suffers, lordship? The beneficiary. The beneficiary who is doing the work, their amount is deducted right from the salaries. It's not that they are,
because their contribution has all along been deducted.
Or deducted. If you are deducting, then why you are not depositing?
Yes, of course.
In Meghalaya college teachers, we are seeing that after all, lordship, we students, once upon a time we were the students, because of whom? These teachers only.
True. Yes, Mr.
Lordship, may kindly come back to page 18, my lord, of their affidavit.
The affidavit.
And also satisfy why we have come to this court, my lord. Page 18 of their affidavit.
Yes.
Lordship will kindly see, my lord,
yes,
the heading at top.
Yes.
Lordship will kindly see the heading on top, my lord, at page 18. That it is.
Yes.
Lordship will see summoned to appear for a hearing under section 14B of the EPF and MP Act 1952, an order for payment of interest under section 7Q for belated remittances made during the period, kindly take note, my lord, 1/4/1996 to 31/3/2014. So this notice was issued to me for this period, my lord. Now, lordship, my friend has referred to the table
Yes.
And it is what she is trying to say, my lord, is that any due which was payable up to 25th of September 2008 would be calculated at 37%, and dues thereafter would be calculated at 25%. Whereas, my lord, the scheme does not say so. The scheme does not distinguish between 25th or 26th. If lordship sees the scheme which has been quoted in the judgment passed by this honorable court at page 33 of my writ petition, my lord, which I had referred to earlier.
Yes.
Page 33, my lord. The scheme is quoted as it is. There is no distinguishing, my lord, that up to 25th I am supposed to pay this much, and after 26th I am supposed to pay 25%. It is a direct calculation of 25%, my lord. From where they have modified this table and they have put their own interpretation is not known to me.
Oh, that should, you see, yes.
And especially considering, my lord, that this earlier round of litigation was for a period up to 1999.
Just a moment. Where is the specific notification, or is this part of the act?
This is part of the scheme under the act, my lord.
Okay.
If lordship will kindly see.
Where is the body of the scheme? The body, the whole scheme as it
It
is.
will be part of the.
Lordship, the scheme is in the act only. The schemes is included.
32A. In my friend's copy, is it at page 95, my lord?
I'll come to that then. I'll come to that also. Lordship, now what my learned friend has already mentioned, if 30, the scheme is there with you, Lordship? I don't think so. Lordship, you can take my. Lordship, here, section 14 is not, section 14B for the damages, it is not there. 14B, this one, Lordship, 14B, regarding 14B, it is not mentioned also, Lordship.
I'm just looking at the scheme.
The 32A, Lordship, down 94, page number 94.
Yes,
Down.
yes.
Yes.
If I may read, my lord.
This is what has been quoted in the judgment.
Word to word, my lord, and there is no distinguishing.
No, we are talking about that. Where's it? Written about the
37%.
Noted about the 37%.
Lordship, I'll if the scheme part, if Lordship go entire reads the schemes part, then this scheme, Lordship, now the summon part, what the summon says, Lordship, and whereas under section 14B of the Act, where an employer makes default in payment, Lordship, yes, payment of the contribution or any charges, the commissioner is required to recover by way of penalty such damages not exceeding the amount of arrears and the rate of damages and damages at rates specified in 32A of the EPF scheme 1952, para 5 of the EPF 1995 and 8A of the EDLI schemes 1976 as given below.
So where are these schemes?
So the
this EPF scheme 1995, is it here?
Lordship, yes.
It is here.
It's here.
Cumulatively, it comes down to this table, Lordship.
It is the calculation what, because if we directly go to 32A,
yes,
it is but the entire schemes we have to go.
No,
so according to calculation.
32A specifies we are concerned with this 25% part. So here it says 25%, but in your table you have specifically a mark up to 25/9/2008 it is 37%.
Yes.
And I can just explain, Lordship, why they have taken that plea. Lordship, may kindly come back to page 33, my lord, of the judgment. Page 33 of the writ petition, where the judgment has.
Not going to inform me. Sorry. Yes.
Lordship has page 33 of the judgment, my lord.
Yes.
Lordship will kindly see just before the quoted part However, it begins with however. First, my lord, they talk about the
Yes,
apex court judgment.
however, the
and
law.
However, the law on this point has now been changed by way of amendment of the EPF scheme 1952 in 2008, which
Okay.
came into force with effect from 26/9/2008.
Oh, yes, yes.
So that is where they are trying to bring that difference, that before 2008, it ought to have been as per the unamended scheme.
Okay.
But in my humble submission, my lord, if lordship has seen that earlier also, before the scheme was amended to 25%, it was the judgment of the Honorable Supreme Court that you are supposed to pay 25%, which is my lord AR 2006 SC 1767.
But that is not that is not the issue here.
Yes,
Now we are
and thereafter, my lord,
now we are here on a scheme, under the statute.
Under the statute.
So
now,
if the scheme here, prior to 26/9/2008 says 37, and from 26/9 it says
lordship, yes.
25, then that has to be taken.
Yes, and what is crucial here, my lord, is not when the damage accrued. It is when they have asked for it.
Okay. So
And that will be very much
so when the
clarified,
demand
my
was made.
when the demand was made,
And not when the
when the claim was, yes.
when the default occurred.
Yes, lordship will kindly see paragraph 5 of the same judgment at page 34. And I keep reiterating, my lord, that they have not challenged this judgment, they are bound by it.
Yes.
Resultantly, this writ petition is allowed. Impugned notice dated 6/3/2009. So the notice was made after the amendment. And the period, my lord, respondent author therefore directed to allow the petitioner to pay 25% as per the amended scheme of the total damages for the period between March 96 to February 1999. So the period was admittedly before the amendment came into the picture. The demand notice came after the amendment, and the Honorable Court, both in view of the earlier judgment, which had been further amended in 2008, has given us a direction to pay at the rate of 25%. And it is between the same parties in the list, and they have not challenged the finding of this judgment. At this point of time, my lord, they cannot come and say that they cannot make this table in the first place. And moreover, this table which I had shown is for a period of 96 to 2014 on the first line of the period. But whereas in the final order, they are saying 92 to 2008. So this notice is not at all, my lord, preceding the impugned order. That is why I have humbly submitted, my lord, that
Lordship,
these
in
are-
my
if I may just
directive.
finish, my lord.
Okay.
These are what happened, my lord, is that they issued us a notice. We tried to go and clarify to them that see, there may have been some mistake. Thereafter, after due deliberation, certain payments had been found to have been paid, but they had initially issued the notice to us. They have calculated it, this and that, and they have eventually issued us a recovery certificate. In that recovery certificate, again they made a mistake in the period. We came before this honorable court, my lord, on 31st of May 2023, saying that the notice period which was issued in the notice and the period which has been reflected in the eventual recovery is altogether different, and we have not been provided with any such calculation for that. What they did, my lord, is they issued a corrigendum after we have approached this honorable court to rectify that period, and they have said that the period will be considered from 92 to 2008. Now my humble submission is, my lord, that 25% which has been directed to have been paid, even if it was assumed that it was between other parties, the law is very much clear, my lord, that 25% has to be paid for any period which is exceeding 6 months if the demand has been made after the amendment has come, and that is what the judgment also has said, my lord. And they cannot go beyond this. They cannot come and say that the earlier counsel was not proper, or they should have, or they wanted to challenge but it is too late. They are bound by this judgment, my lord.
In the apex court judgment, does it also say so?
Apex Court judgment directed for 25% even
Halvasia's
prior to
case,
the amendment.
Lordship, in Halvasia's case, there is, because it was, interpretation was little bit different. But in Halvasia's case, the judgment is, it seems to be, because now I don't have the Halvasia's case with me. I have it is not there with me. But in Halvasia's case, the interpretation of the judgment has been slightly, by this court, it has been slightly, might be it is taken in a other way around. But whereas the Halvasia's case, it is reflected as 37
submissions at
no,
this point of time.
37% and 25%. So it was very much there that 37% is for what,
Okay,
and
whatever the case may be, this court has, like you said, maybe
Yes.
have interpreted it, in certain manner and taken whatever,
Yes.
and then came to the conclusion that it is 25% and not. In fact, 37% is never at all mentioned.
it was never. But Lordship, yes.
So, as Mr.
They
Day
are
has
bound
said,
by it, my lord.
the point is
Lordship,
this, you see,
yes.
this-
But then Lordship,
in fact, we are also bound by it.
entire things, if hearing is conducted on entire all these things, then they have to file an appeal, Lordship.
No, this is a
The Lordship, entire situation,
an order
there
is bad
nothing.
in law, my
Yes,
lord.
yes, yes.
An
Lordship,
order is bad in law.
If the order is bad in law, they have to go for appeal.
No, I can come to under 226, my lord. This is
Lordship-
wholly without jurisdiction. How
Lordship,
can I be
where is-
asked to pay 37% or anything more than
Lordship,
25% when they
if
don't have the authority?
disputed, then it comes to disputed amount, Lordship. Then they have to go for appeal, Lordship. Where is the provision? Lordship, the Act does not say that they can come under 226. The Act says that if you are not satisfied with the order, you go for appeal. They are not satisfied with the order.
My lord, no act says that you can go to the High Court under 226.
Lordship, if
provided
there
by the
is,
Constitution.
Lordship, if there is a provision, proper provision and law,
The only thing
it's
you
very
see-
much clear.
you see, you know very well. See, in fact, you should know better than me. Under 226, you see, if there is an efficacious remedy, alternative remedy, then the parties are, are prompted.
Prompted, my lord.
But it does not necessarily mean that they are forbidden.
Absolutely, my
Propose
lord.
the act.
Absolutely.
Of course, the court will deal with matter as and when it comes.
Yes.
It's a different thing.
And
You see, now you have raised the issue of maintainability. That will be dealt with.
maintainability from very beginning, I am
So
saying.
that will be dealt with. But then,
Lordship, now the whatever he says, Lordship, that in my annexure I-34, Lordship, I have already pointed out that it is from 1992 to 2008. We have already showed that what is 14B, what is 7Q. 7Q is interest. What is 14B, what is the amount of damage, the account number, everything I have already pointed out in my annexure I of my affidavit. Lordship, also Lordship, in the main order, Lordship, that read petition, page number 39. Lordship, what is the final order we have passed?
yes,
39, Lordship. If I go through the order, Lordship.
yes.
And whereas due to leave of assigned officer, hearing could not be conducted on such and such date, and the next date of hearing is this. Miss so and so, authorized signatory of the establishment, and Miss so and so, principal of the school, attended the proceedings. They submitted the Honorable High Court order wherein the damage and interest for the period of this to this was ascertained, and payment was made accordingly in this regard to the rest of the damage period. They requested for more time to bring the requisite supporting documents. Their request was granted, and the next date of hearing was fixed on this. Received a letter from the establishment requesting some more time. Request was accepted, and the case was adjourned. Mr. So-and-so attended the hearing on such and such date. He submitted a letter of correspondence with the bank wherein they placed a request for the account statement. He requested more time as the bank is yet to give the requisite document. Requested was accepted, and the case was adjourned for this. Mr. So-and-so attended the hearing on dash, and again he requested for more time as the bank is yet to give the requisite document. Request was granted, and the case was adjourned. Mr. So-and-so and Mrs. So-and-so, authorized signatory of the establishment, attended the proceeding. They submitted a letter from the bank stating that it may take some more time for the bank to retrieve the detailed bank statement. However, they submitted the transaction statement from the bank passbook along with the challan copy of the contested period for cross verification by EPF office. Case was adjourned such and such date, such and such date. On scrutiny of the document submitted by the establishment, it is seen that payment of 7Q for the period of this and this as calculated in earlier assessment was paid by the establishment. 14B at the rate of 25% assessed amount rupees this much was paid by the establishment for the period of 96 to 99 as per the court order, and due amount of rupees this was also paid by the establishment. Establishment contention for the wage month of 4/2008 has been taken into account. On scrutiny of challan and bank statement, it was seen that contribution mentioned against this actual pertains to this 4/2010 and payment was made within time. Hence, the damage and the interest was being struck off. Establishment's contention for the wage month of 4/2006 has been rejected. On scrutiny of challan, the bank statement, it was seen that there is actual delay in payment. Hence, 14B and 7Q amount is required to be paid. Revised calculation sheet was prepared and sent to the establishment with direction to attend the hearing, which was fixed on 21/23. Mr. So-and-so attended the proceeding. He was apprised the basis on which the revised calculation sheet was made, and their contention, aside from their damage period, this to this was taken into account. Detailed reason in the revised calculation sheet given. So now this is the revised calculation sheet was already provided to them. Considering on the basis of the challan submitted by the establishment itself shows that there is an actual delay in payment of 93 to 95 and from 99 to 2006, which my order sheet says, which my calculation sheet also says. And adequate opportunity has been given to the the case was concluded and closed. So now thereafter we have derived into this calculation.
So the petitioner have also taken part in this.
Yes, petitioner very much has taken part.
So this is in can you term this proceeding as one under section 14?
Section 14, yes, we have to. Yes, we have.
Provided where the order passed reasonable opportunity. That
yes,
is what
reasonable opportunity. After reasonable opportunity, we have given such and such all everything. So this is a part of the thing, Lordship, and moreover, the whatever my friend has submitted is like it is so to say that we have covered entire thing in our judgment. Now section for 2008 it is 37%. It is retrospective, or whether it will cover from if a crime commits, Lordship, whether if an act is amended. Suppose, Lordship, when prior to 2013, if any POXO case was conducted, POXO case is there, whether it will be tried in 376 or it will be tried in POXO Act. Obviously, it will go for 376. Na, the act will be when the damages occurred.
That is you see, you are stating a principle.
Yes, when the damages occurred that time, prior to 2008.
See here, what we are looking at, you see, is an interpretation, or rather, the impact of a judgment already rendered by this court, where that like you rightly said, with due respect, the interpretation may be wrong, may be right.
Yes.
May be wrong, may be right. But the point is that since it has been passed, as of now, it has become final.
Absolutely.
Now, see,
we have taken that. We have admitted to 25%. We have taken. We have not calculated that amount.
You have not calculated 37.
No, we have not calculated. We have 99 to 96 to 99. We have not calculated. From 92 we have calculated. We have not taken into account. My order sheet says so. That is why I have brought your Lordship attention to my order sheet.
So you mean to say that the calculation that you have made was 25, not 37?
No, at 37.
37, but not with that judgment order. The judgment order is for particular period, na?
Yes, yes, yes.
For that particular period, we
That
have
is-
not
that is for
taken it.
96 to 99. Huh.
We have not taken into account. If we have taken it as a paid, the order sheet says so.
No, that's true.
Yes.
What I think Mr. D has said, and what this court has also observed,
Yes.
is on the basis of that judgment, what should have been calculated should have been 25. In spite of the fact that the period pertains to, prior to
2008.
26/9/2008.
Yes.
As on 26/9/2008, it has become 25, but prior to that it was 37.
37.
But then, since the notice issued was after
Yes.
2008, then if we go by the by a reading of the judgment, it means that it should have been 25 and not 37. That is the only point that
And
Lordship,
could
now,
have
I am only trying to say that this 4,67,000 odd amount which they have claimed against me, I will pay 25% of it. And that is a question of law, my lord.
Lordship, the beneficiary will suffer, Lordship, and moreover, we have to think about the beneficiary also. We cannot think only about the management.
No, that's true. That's
We
true.
have to think about the beneficiary. Beneficiary will
see,
suffer because it will go to the pension schemes also, Lordship. And moreover, the thing is that if any crime is committed,
No, I got your point.
if any crime is
What
committed,
you can do is, see, I think you understand the query of the court.
yes,
Only with regard to whether, you see, 37 is to be taken or 25 is to be taken,
yes,
and the relevant period, see, whether, you see, pursuant to the notice that you have issued after 2008, whether only 25 will apply, or it will also, have a retrospective effect as regard the, imposition of 37%. You understand the point? So if you can, just, assist this court by giving some relevant authorities,
okay,
just to explain the principle or how it is to be in such a situation. Because why? You have to understand that this involved a case, an order passed by this court, which has become final.
yes,
And this is a coordinate bench.
Absolutely.
It cannot,
And moreover,
cannot override.
they are bound because there is the same
And
organization.
since, yes, okay, whatever the case, it could be, and yes, they are bound because it's between the same parties.
Yes.
So, it's not a question of empathy or sympathy, whatever the case may be. It is a question of application of law in the correct perspective.
Absolutely.
So, if you have a way out, of course.
Gotcha.
Even I'll try to, even those Supreme Court judgments which were referred to, I'll just try to, my lord.
Yeah, and that, and
Halvasia's case. Okay, we will.
even so, how the court has interpreted, we can see that.
So whether that was right or wrong,
At this point,
at this point we cannot really look into it. That is the only thing.
That is, you see, that is how you understand. You should understand the policy of a person. We may say, I admit I don't know each and everything. I may pass a wrong order.
Lordship.
All we know, which is allowed under the system. It is allowed because there are higher courts to correct, such wrongs. But if you don't, you see, like they say, you see, Supreme Court order is what do we call it? Final, not because it is correct, not necessarily correct, but because it is
highest court.
The highest court is the
Highest
final.
court. Yes.
Absolutely.
So, if you pass the wrong order, then the wrong order.
Absolutely.
Nothing can be done about it.
Lordship.
And this has happened, of course.
Many a times, my lord, we have our personal opinions that this judgment is not correct, that is not correct, but we cannot help
That is
it.
the system.
We
That
cannot
is the
help it.
system. So please try to do. In fact, what you can do is try file your written argument with those authorities and those points. Just make those points clear, so that this court will be easier for this court to to decide.
Gotcha.
As far as the will allow you to be heard on the next date.
Not sure.
heard legal counsel for the petitioner as well as legal counsel for the respondent number. You are respondent number?
Respondent 1, 2, and 3.
1, 2, and 3. The legal counsel has something that they may be allowed to file written synopsis of their argument as well as relevant authorities in this regard. As far as respondent 4 is concerned, prayer is made for accommodation on the ground that the learned conducting counsel is indisposed. Accordingly, the respondent 4 will be heard on the next date. This is matter to 2 weeks.
Okay. Supplementary 1, item number 1.
May it please the court, my lord. If I may begin with the submissions, my lords. Lords, this case concerns the exercise of auctioning of mortgage properties for realization of pending dues. Now, I'll take your lordship through the facts of the case in brief. Now, what happened, my lords, is that in the year 2012, the petitioner, Mr. Kit Boklang, for the purpose of opening a car dealership in the East Khasi Hills, approached the State Bank of India for availing certain loan. Now, help was granted to the petitioner in 2 forms: a term loan amounting to 3.2 crores and to 3.7 crores, and a cash credit line amounting to 3.2 crores was extended to the petitioner. Now, this total amount, the principal amount, comes to a total of 6.9 crores. Thereafter, the petitioner opened a Tata dealership and he was repaying back the loan in equal installments in a very regular manner. What happened, unfortunately for him, the Tata dealership broke down in business and went bankrupt in 2015. After that, he was not able to repay back the loans. Thereafter, the bank proceeded for realization of the unpaid dues. And in pursuance of the same, they approached the Debt Recovery Tribunal by way of an OA, an original by securitization application, and the same was disposed of last year in 2022. Now, without wasting any time, I'll take your lordship to the relevant portion of the DRT order.
Just a moment, Mr. Sahu. Why
Yes.
is this petition filed before this court?
It's because we're not challenging the order of the DRT. We're not challenging the order of the DRT.
We're talking about the rooster.
Yes, Lordship, because it was listed, we had mentioned it before, Justice, thank you. And from there, he asked us to approach appropriate bench.
Appropriate bench? In what sense? No,
Your lordship, we were in...
You may be aware or not, but then writ petition matter of pertaining to 2023 are to be listed before
Yes.
the other court.
Yes, Lordship, from the registry, Lordship, we were informed to.
When we approached the justice, thank you, we were informed by justice, thank you, that he would not be available for taking up mention matters, and then he instructed us to mention before this court. Therefore, we are before this court. We had approached justice, thank you, first in the morning at 10:30 itself. That is the difficulty, and the urgency in the matter is that the recovery proceedings are to be taken up on Tuesday itself. So,
again, you see, without issuing of notice, how do we?
Yes, a notice may be issued, but till that time, the recovery proceedings may be stayed before any forum, because if the recovery proceedings are proceeded with, then the entire writ petition becomes infructuous. Because this concerns the auctioning of a mortgage property. There were 4 properties in the name of the petitioner. One property was split into 2. Those were 2 contiguous properties. They have been clubbed as one in the auction notice that is has been annexed in the writ petition also.
Impugn notice?
The last annexure. The last annexure.
Annexure C, Lordship.
C. Your Lordship, we're not challenging this. But here, your Lordship will find that from the second paragraph, I'll read out the relevant portion. CHB has filed 2 valuation reports of mortgage property mentioned in so-and-so schedule. As per valuation report given by Mr. Pranjal Bhagwati, realizable sale value of the mortgage Schedule B property is rupees 3.4 crores, and valuation report given by so-and-so is 3.9 crores. The mortgage property will be put into auction sale in execution of the recovery certificate on the basis of valuation report given by Mr. Pranjal Bhagwati, which is having realizable value as rupees 3.4 crores, considering the earlier auction of property mentioned in so-and-so, which has failed twice. Now, the next paragraph, all CDs are directed to appear in person on 28/11/2023 at 11 a.m. 28 minutes, which is on Tuesday, and before that, Monday happens to be a holiday, and yesterday was also a holiday. Therefore, we're preferring this for hearing today, Mulats. Because if no order is passed today, then the recovery proceeding will continue, and that will greatly prejudice the interests of the petitioner, Mulat. And if I may just quickly point out, Mulats, the principal amount was 6.9 crores. The petitioner has paid more than 8.6 crores, more than 8.6 crores. 3 of his properties have already been auctioned off, and we have no quarrel with that.
No, the fact remains that the interest element is also there.
Yes, absolutely, Mulad. That's why we have not challenged the DRT order. We have accepted it. Your Lordship will find at the last page of the first annexure, just 2 pages prior to this page, Your Lordship just saw. Your Lordship will find at a slew of directions were issued by DRT, and at the direction number 12, the direction Roman number 12, Your Lordship will find that the DRT has ordered recovery certificate for a sum of rupees 8 crores 39 lakhs. 8 crores 39 lakhs in favor of the applicant bank against the defendant number 1, 2, and 3. 8.3, Mulats. 8.3, and this order was passed last year in 2022. 8.3. And Your Lordship may kindly come to the next page itself. The next page itself, Your Lordship will see that 3 of his properties have already been auctioned off, and the cumulative amount, the first property sold for an amount of 4.4 crores, the second for an amount of 1.4 crores, and the third for 2.83 crores, bringing the total to 8.69 crores. The DRT ordered 8.3, and the bank has already recovered 8.69 crores. And we understand that there may be certain interest elements due for which they have not given us any calculation. And if I may bring to the notice of Your Lordship also, that the moratorium period has also not been executed by the said bank, my Lord. No communication in this regard has been given. Therefore, for now, my Lords, our humble prayer before this honorable court is that the recovery proceedings may be stayed, and then if for now, my Lords, the recovery proceedings are stayed before any forum, because we do not know what they are doing. They've already sold off 3 of our properties. This is the last property that we have, and we will be rendered homeless. And they've already, if it was the case that we had not paid any amount, then yes, they're liable to proceed. But we've paid more money than what a DRT ordered, and they're still going to auction off our property, which is valued at more than 3.4 crores. More than 3.4 crores. Therefore, with that, my Lord, I like to make a humble prayer that the proceedings, not just before the DRT, any recovery proceedings may kindly be stayed till the disposal of this writ petition. Lord.
You are?
Anjan Sahu, my Lord.
You are? Anjan
BB Sahu. I'm BB Sahu.
BP or Anjan?
Yes, Lord.
Who's BP?
Anjan.
Lordship, BP Sahu's senior advocate.
Yes, but his name appears. Heard Mr.
Anjan Sahu.
Anjan Sahu, counsel, appearing for the petitioner, who has submitted that the petitioner, being aggrieved with the order dated 27/10/2023, issued by the Death Recovery Tribunal, Guwahati, wherein the process for recovery of 3 crores 95 lakhs 29,000, which is the
3.42 crores, Lord. 3 crore 42 lakhs.
Oh, sorry. 3 crores 42 50 thousand more.
Yes.
which is the value of the property. This is the property of the petitioner. Mortgage property.
Yes, my lord. The petitioner.
Which
Yes,
is
my lord.
the value
Mortgage
of the
property.
mortgage property of the petitioner. Has been. Apa ni yang di last paragraph? And for which the said mortgage property is directed to be put in auction sale towards recovery of the said of a set amount, which in effect will prejudice the petitioner as much as he will be left with no remedy against the same if the said order is put into action, which is slated to be held on 28/11/2023 at 11 a.m. This being the case, at this juncture, before notice is directed to be issued against the respondent, the General Counsel has submitted that an interim stay of the impure order may be passed by this court. This court, on consideration of the said submission and on perusal of the impugned order, without going to the merits of this petition, at this juncture would direct the petitioner to take steps for issuance of notice upon the respondent. Public State Bank of India. Next, as prayed for, in the meantime, the impugned order dated 27/10/2023 supra is hereby the operation of the impugned order is hereby stayed until the next date fix. Notice to be issued is returnable within 2 weeks. This is the matter thereafter. So we take steps.
Obliged. And if I may make a small prayer that a copy of the order may kindly be made available, if possible, uploaded or through any other means. Lord.
By evening you will get it. It will be
obliged.
Miss.
Deeply obliged. Deeply obliged.